pulled out the wrong speech and started reading. There were two speeches.
Honorable judges, past and present, and distinguished members of the audience, we are running out of time, so I'll be brief, and my co-panelists. When we decided to have this book launch, I was trying to find out any particular individual who has actually heard the arguments in K V Viswanathan, which started in 1972, mid after August, and ended in March. And I was just finding, because when I did the courtroom genius with Mr. Sorabji in 2002, 2005, many of the people were still alive. And I was wondering who could be the person who could speak about the arguments if he was personally present. I know Prashant Bhushan was there for the review. And when this panel was formed, I just spoke to Mr. Kapil Sibal and I said that, were you in law college when this matter was heard? He said, I was enrolled in 1972 and I attended the entire hearing of K V Viswanathan. So we have the unique privilege of a person who has actually heard the arguments, and he says he heard the arguments in the review as well, as a lawyer who had just started his practice. So we are indeed extremely fortunate that we have Mr. Kapil Sibal, who was witness to the arguments, and he has gone down, he'll go down memory lane. So I thought we can start the panel discussion with his recollections of what actually took place in the court. And we have decided not to have speeches by all of us, but just freewheeling comments followed by a question-answer session. We'll try to keep it as light as possible, but let us start with the most important, Mr. Sibal, who was actually present in court.
I just enrolled. Good evening, everybody. I just enrolled in the bar, and I was a briefless lawyer, so I would normally go from court to court watching judges. And when I heard that this matter was on, I went to court 1. And there I saw Nani Palkewala arguing. And the one thing that struck me was that he never looked, though Rohinton says that he cited several law books, but while I was there, he hardly referred to any law books. His understanding of basic principles of law, his felicity of language, his love for literature, he just mesmerized the court by telling them the differences the differences between meanings of law and the Constitution. What does law mean? What is the Constitution? Basic principles of law he enunciated with such great clarity that anybody who was in court was just mesmerized by his forensic abilities. And quite frankly, I have also had the privilege of helping him in some cases. And what I found was that Nani never really cited the law to make the law. He, in fact, made the law by not citing the law. He had the ability to encapsulate principles of law which do not find place in any judgments. And then that's how he developed sales tax law, that's how he developed income tax law, that's how he developed constitutional law. And I remember when the review took place, he argued for a couple of hours, and he didn't look at any book. He referred to no book. He just argued for 2 hours non-stop, and nobody could ask any questions from him at that point in time. So he overpowered the court by just his presence. And he never hesitated on, when a judge would ask him a question, he would have a ready answer for it, and a very fine answer for it. So what I learned from him, and I think all lawyers, and this is what I wanted to say today, all lawyers learn that lawyers are meant to develop the law. If you start looking at judgments and start now looking at the law and say you must follow this law, you'll never be able to develop principles of law. So the one thing that we must do when we go to argue, and this is what I learned from Palkhiwala, and I followed it, I've followed it all my life. Look at the facts, know basic principles of law, and develop them in the context of where you want to go and where the legal, where law should be, because ultimately law is a vehicle for change, and new situations come up in the country which require change. And what Rohinton has said, and quite frankly, today the basic principles are here to stay. The basic doctrine is here to stay. Nobody can change it. In fact, Article 359 of the Constitution itself says that even in a national emergency, Article 20 and 21 will remain in force. Now, once there is a constitutional provision which says that, nobody can change the basic structure of this country. But the real challenge, and that's why I want to start to this discussion, is that you don't need to violate basic structure by changing the principles of basic structure. You can violate basic structure by bringing in ordinary law, which is contrary to the basic structure of the Constitution. And the principle laid down in Keshavanand Bharti is that basic structure is only a concept which is applicable to the constituent power of Parliament. But if you have laws which are contrary to the basic structure, you can't challenge them on grounds of basic structure, but you can violate basic structure on a daily basis, and that's what's happening in this country.
Can you start the mic, please?
Use this.
Yeah. Yes, can you hear me? Yes. We'll start the discussion, and I'd start with Justice Sikri. And sir, is there any particular way you'd like to describe the justification behind the basic structure doctrine? Sorry.
Let me take this. Here.
Yeah. Okay.
Thank you very much. First of all, let me congratulate our very dear friend Rohinton, who has brought this book in his inimitable style, as he does always. And in 15-20 minutes, I think he has been able to describe what this book is and what the basic structure doctrine meant. Since you have asked me to describe it in my way, and going by what Kapil also said a few minutes ago, that we should not go to the precedents or the case law to advance our point, and we should try to create our own this theory about it, and it's our duty to lay down law. So I see basic structure doctrine from a different prism. And what the majority said in Keshavanand Bharti, and as Rohinton has already mentioned thereafter, it has been not only it's firmly established, and it is the view already expressed by Rohinton as well as Kapil that it is here to stay and it cannot be, and I am also of the same view, it is here to stay. But let me go just prudentially and go to the basics of it. We are a democratic country. We are a constitutional democracy. And our preamble starts with the words, we the people. So the main thing which I am emphasizing is that it is the people of India, we the people, who have given ourselves this constitution. And another very interesting attribute, or a very important, pertinent attribute of our constitution is, because there can be various kind of constitutions and even various kind of democracies. It can be, and we know of the countries where it is very limited democracy or only a formal democracy as we call it. But our constitution has given what I say, and the jurists also say, liberal democracy, because it is not only the constitution but all the attributes of constitutionalism which have to be in a constitution are prevalent there. We have, based on this, yes, fundamental rights are there. We have, which ensure that the people in this country enjoy these basic rights and basic freedoms. It is, as I always say, is based on the dignity which is to be recognized in the people of this country. And it is based on the identity also, which we have to formally give to the people of this country. Then we have directive principles of the state policy, which cast a duty on the state for better governance and better this thing. Of course, we have the elections and majority is there to rule, but then it is in the scheme of the constitution again that the majority will rule, it will govern, but it is not that it is given a carte blanche, and it can govern in any manner it wants. Again, the power of governance are also prescribed in the constitution, and every elected government has also to act only in accordance with the constitutional provisions. This we call either, it can be two expressions which can be used, that it is a matter of limited government, that government is limited by its power given under the constitution. And another attribute of it is that it is the rule of law which prevails. So in a matter, in this scheme of the constitution, and when we have a substantive democracy with constitutionalism, and we now come to Article 368, which is the power. So in a matter like this, or in a scheme like this, whether when this power was given to the parliament to amend the constitution, whether this power included the erosion of all these values which are there, and which is the bedrock of our constitution. And I again go back to this what we call social contract theory, which was developed by initially Thomas Hobbes. And when we say we the people, and we have come together, and we have agreed that we will vote, there will be franchise, and the elections, and the government which wins will have right to elect. But that doesn't mean that we have ceded our authority, we have ceded our freedoms, and therefore these are always uncompromisable. So some of the elements which were given, or which are there in the constitution, if we look into from this angle, then the obvious conclusion would be that we the people never gave any parliament to take away the main characters of the constitution. See it from another angle. If we see Keshwananda Bharati and what Justice Khanna has also said, as far as fundamental rights are concerned, these are unamendable except the right to property, which he said on that also there may be debates, jurisprudential debates, but we are not going into that. Then secularism, fundamental rights, this democratic form of the government, judicial independence, three wings of the government, and separation of powers, etc. These are the attributes of basic structured doctrine. Can there be, even if you take it when the power is there or not, have we ever visualized a country or a governance where these would be taken away? Tomorrow we don't remain the secular country, or we take away the fundamental rights, or we take away the minority rights, which are taken as the basic feature, or judicial power which is there and which has been stated in so detailed time and again. Can we take away that power? Rohinton has already given so many examples. So therefore, according to me, this is the basic support, or this theory, which again says that Article 368, amending power is there, but that amending power does not take away and there is no such power to take away the basic rights.
Thank you, sir. Now thank you for your comments. Yes. I'll now just go to Dr. Singhvi for a moment. And it's very easy now, after almost 50 years, to say, basic structure is so obvious. It's obviously the Constitution has a basic structure. But if you go back to the 72 when the matter started, and if you see the written submissions of Mr. Nirende, Mr. Sirwai, and so on, there was a really strong feeling that the power under 368 was untrammeled, uncontrolled. So I'll ask Dr. Singhvi, the argument, if you see the submission, was that to say that Article 368 doesn't have complete power. You are really questioning the will of the people, and the constant argument was that if you allow the Supreme Court to strike down a constitutional amendment, it will be anti-democratic and counter-majoritarian. These are the exact words used. What is your view? Now, of course, let's go back to 72. Because it's a wafer-thin majority. You see, in fact, I tell people that it's not 7:6, it is 6.6:6.4, because Justice Khanna went all the way, and it's just on 2 paragraphs on the essential features, the whole thing twisted. I mean, just our entire fate is just on a few paragraphs. Dr. Singhvi.
Thank you, Arvind. Let me take 30 seconds to say that when Rohinton speaks or writes, we all listen. The world should listen and does listen. And it truly requires a path-breaking doctrine to be dealt with in a book-length treatment by a pathfinder. And Rohinton has done great service. I've seen most parts of the book to have dealt with it. It's suffused with his usual glow of analysis, historical evolution, international comparison, and above all, you saw his brutal candor. That's very important. Of course, I must add that those who in contemporary times act like ill-informed, casual, or motivated commentators on this complex subject should realize the amount of depth of knowledge they have to first garner before they can comment in a very casual fashion on this important doctrine. Having said that, Arvind, the question you asked, you're absolutely right. So what is Palkiwala and what is Keshwanand credited for? Clearly, the first official, complete, proper embedding of this doctrine in a juristic sense. But what is interesting is, and I want to bring this to your attention, the universality of the seed of thought which lies under the basic structure. It is quite incredible that the same seed of thought in different formats, without of course a judgment, is there from the 1920s. In 1920 you had unrelated people, a Carl Schmitt in Germany, a Hariwu in France, and even Kelsen around that time, talking of very similar concepts, but from different philosophies, different viewpoints, different locations, different ecosystems. All of them in the 20s is rich with this literature. How it then, and I'm sure it must have found its way into Konrad Dietrich through one of these writings. And then it found through the BHU lecture. Rohinton mentioned about the Chagla Daftari, but I am told it also found its way to Mr. Rao, who carried it to Mr. Nambiar, who then said, I am too old and unwell, so carried it to Mr. Palkiwala. But the point is, the universality of this crosses boundaries, crosses time phases, crosses nationalities, and ultimately what you find in Keshwanand is also at the second level in a universal theme running from Shankari through Sajjan, through Golaknath. There are only differing zigzags, but the basic seed idea is there. The other thing I want to put to you, it's a God forbid shocking thought, but I think we should spend about half a minute or minute on that. It's quite clear now that you can't take away basic structure by a constitutional amendment. The highest you can do is a constitutional amendment. You can have a 2-line one, thou shalt have no basic structure. That will not survive. So is there a way in which you can do away with basic structure? Well, one clear way would be a referendum. Fortunately, in our country, it is now judicially held. Golaknath was very, very scathing about why no referendum. But more recently, referendum has been rejected in many judgments, including in the Jammu and Kashmir 370 case. So that one way is out. So lastly, perish the thought, the only way you can do away with basic structure is to do what Justice Ray tried, revisit Keshwananda Bharati. The last time that happened, basic structure got even more and better embedded. So I hope and trust that those kind of misadventures don't happen in the future. A quick word, we've counted in his book 9 plus 11, about 20 countries, which now follow it in some sense or the other. It is tragic, beyond words, that the inventor, the pioneer of something which 20 countries across the world give huge credit to India for, occasionally talks of backtracking on this subject, which is why I said that this is something for which India should be proud. It's a gift of India to the world jurisprudence. Thank you.
I may just tell the audience that Kesan Bharati had 6 writ petitions. It had 20 interveners and 19 states were given notice. And as a matter of information, Dr. Singhvi's father, Dr. L.M. Singhvi, was the Advocate General for Rajasthan who supported the argument against the basic structure, of course, at that point of time. So we've got Dr. Singhvi's father who was involved and Mr. Kapil Sibal who was personally involved.
Physically there.
Yes, yes.
So he doesn't want it to be an admission of his old age. Huh? He's remarkably energetic.
That we won't ask anybody. But it's a privilege to have you, sir, because not many people had the chance of... I just heard him once in the tribunal, income tax tribunal. Anyway, coming to Justice Viswanathan, what is your understanding of how do you take the basic structure theory? I mean, we're students when this entire thing came up, the basic structure theory. And you've been a lawyer and now a judge, so...
At the outset, let me congratulate Rohinton. 2 weeks back when Nina released her book and Justice Ramasubramaniam released it, he referred to Rohinton and said he never wanted to be called the chip of the old block. But you will permit me if I borrow the words of the late G. Ramaswamy and use the phrase that Rohinton may not be the chip of the old block, but he is the block of the old chip. In every sense of the word. And this book is only an example. I can put my hand on the heart and say that I've read most parts of it till the later portion dealing with the other jurisdictions which I've borrowed. And it's a fascinating edition. You get a feeling that Rohinton is arguing in court. It's remarkable for its chilling clarity, but what it does is that it gives you the build-up to Keshwananda. It starts with the first case, Shankari Prasad, goes on to Sajjan Singh. All that you will see it in the book. It's not my endeavor here to, go over that. But as far as the very theory is concerned, what fascinates me, Arvind, has always fascinated me is the soundness of its logic and its strength in its jurisprudential soundness. If I were to write something like this, I'll have the joy that a lawyer would have on the evening of his arguments if he had found an unanswerable point to the case. That it has endured for so long, and it's, unless you come out with a strong theory to oppose it, which none of the critics have as yet come forward to, the theory is here to stay. And you will appreciate the effect of the theory only if you see the illustrations that Rohinton gives in the concluding chapter of the book. He takes off from Dieter Conrad's 2 illustrations about what happens if, there's an amendment about the country being now told that you will only have Hindustan and one other state.
Tamil Nadu.
And
that's what Dieter Conrad says. Can be only Tamil Nadu and rest of
he
India.
now develops that and says, if all this were stopped, it's because of the basic structure theory. And the first application of the doctrine came in the Indira Gandhi case, which he dealt with. And if you think of the
Original article
nature of the amendment, that an election can't be called in question in a court of law and a pending appeal will abet. And all the judges who had hitherto, who were daggers drawn with that theory, came around and said, no, we can't have any of this. And the strength of the basic structure theory will be best appreciated if you view it with the illustrations that are given, that have been neatly tabulated in the book. Justice Singhvi, Mr. Singhvi raised a point on a referendum. If you refer to Rohinton's earlier book, The Discordant Notes, he refers to a question by Justice Palekar to Palkiwala. And I thought that was what Rohinton called the most difficult question which Palkiwala encountered in the entire hearing. And the question was, Mr. Palkiwala, you are advocating this theory of basic structure. would you do this if 368 in its original form had always provided for a referendum? In which case, then you are really not against the amendment being proscribed or basic structure, being a theory which is to be implemented, but you are on the procedure that is prescribed now because it's Parliament which amends with appropriate ratifications in given cases. But if it were a referendum, could it amend the basic structure? And Rohinton says that Palkhiwala had difficulty answering. But today, with 368 in the form that is in, it cannot be substituted with any other form. And in my view, even if it were to be a referendum, since certain fundamental rights are natural inhering rights, they cannot be taken away. They are put behind the hands of the majority. And if fundamental rights are the limitation on even the legislative power, and today, even in a referendum, it could not be taken away. But that's out of question now. So the strength of the basic structure can be best appreciated if you illustrate them with concrete examples, and it's a very sound theory. The other argument which came closest to challenging it was by Justice Kanyailal Mishra. I read this in Rohinton's father's book, that one of the reasonings given by many of the judges who adopted the basic structure doctrine was that Article 368 used the phrase, the Constitution will stand amended. So ultimately there has to be something which will remain, which will stand amended. It can't be that you can repeal the Constitution in entirety, and equally so you can't remove the basic structure. So it appears Mr. Kanyailal Mishra countered this by saying, could the draftsman have said the Constitution will sit amended? It's only a manner of expression that it stand amended, and he was trying to belittle the argument. But I think, but for this, if you see the critics which you have highlighted in the note that you circulated to us, none of them even come close to offering a possible alternative, which would safeguard the constitutional values and then, leave an enduring impression. So in that sense, the theory is here to stay. But having said this, I must also end on a lighter note, that it appears Keshwananda Bharati, who was the head of the Ilanir Mutt, his case was chosen first by Mr. M.K. Nambiar because he thought if a mutt challenges it, it will have a better impact. But Keshwananda Bharati himself had no clue of what the challenge was. And the joke is that every evening, 6 o'clock, when the All India radio would have the news bulletin for 68 days, that today the Supreme Court heard arguments in the Keshwananda Bharati case, he would send for his attendant and ask, what's going on? Why is my name coming in the radio every day? This is a story circulating in Kanjangad. But every case leaves a history. And so when Keshwananda Bharati passed away a couple of years back, and the press asked me, I said, he may not have known about the significance of the case, but his contribution is so vast. Just as England have erected a statue for Donoghue in Scotland, after the famous Donoghue versus Stevenson case, it's time we at least have a portrait or a statue for Keshwananda. So I once again congratulate you. I would request each one of you to read the book. It's a remarkable treatise. It gives you the background, it gives you the argument, some of the fascinating points raised. Justice Matthew, who was in the minority, most of the judges said fundamental rights are conferred and they don't inhere. Justice Matthew's conscience wouldn't permit that. He said no, it's a natural right. But then how do you permit that to be amended? He invoked the salus populi suprema lex doctrine. He said it will cede to public interest. So he considered that it was a natural right which inhered. Constitution only recognized it, but he said it will cede to a higher right. Even the minority opinions are fascinating. the process, the thought process, the reasoning. It will inspire any lawyer. It certainly inspires me as a judge. It certainly inspired retired judges. So congratulate you, Rohinton, once again. At the bar, he kept raising the bar. As a judge, he led the way. The problem is he's not keeping quiet even after retirement. So I wish the book all success. I wish Rohinton many more books to his pen. And thank you very much for coming over this evening.
Thank you. Just wanted to also tell the audience, you mentioned about Justice Matthew's dissent. In fact, I was rereading the judgment, and those of you interested, in para 1692 of the judgment, Justice Matthew says that the right to freedom of speech is the matrix upon which all the freedoms are founded, and nobody can deny that freedom of speech is an essential feature of the Constitution. He says so, but he says it is amendable and therefore it can be taken away. Larger. Yeah, larger. Mr. Sibal, you are the party in person in the audience, but could you say some few words about basic structure before I throw it for question answers?
Yeah, the thing is, you talked about referendum, but you must remember that in the 45th Constitutional Amendment in 1977,
Bill by Shanti Bhushan.
Bill in Shanti Bhushan brought, this was exactly what the bill said, that if there was to be a referendum, right, and that referendum said that the theory of basic structure doesn't exist, right, that unfortunately for us, that also was not passed. It fell in the Rajya Sabha. So this attempt was made. Yes. I just wanted to point that out, that referendum theory really did not pass muster. But I want to suggest another point of view here, which is that no power and no exercise of power is limitless. Recently you saw a judgment of Justice Pardiwala and Mahadevan, when they ruled that, look, the government has to decide within a time frame. So when you look at the Constitution and the articles of the Constitution, you will find that there is, if you were to interpret the Constitution, the inherent inhibition in the exercise of absolute power actually is found in the Constitution itself and its various articles. So the basic structure theory did not say anything more than that. And I wonder, even if they had held that there is no basic structure of the Constitution, a time would have come when in the exercise of power, courts must have realized that there is no absolute exercise of power, and there are inherent limitations in that. And you will find that in each article of the Constitution. So I imagine that at any given point in time, this basic structure theory would have come about through judgments of the court of law, despite the epochal judgment that was rendered at that point in time.
Yeah, Dr. Singhvi, sorry.
That's number one. That's number one. Number two, and my worry now for the future, and I said that in my opening remarks, that there are several legislations today that are operating. If you were to, through an exercise of constituent power, pass that amend the Constitution, it would be contrary to the basic structure. But outside the Constitution, they already are violating the basic structure. You see that they are violating federalism. They are violating the secular fabric of this country through existing legislations. Now, you can't challenge those legislations on the ground that it violates the basic structure. You have to have them struck down by virtue of Article 13, because they violate Part 3 of the Constitution. That the courts are not willing to do. So the result is that despite the fact that the basic structure doctrine has gone away, yet the fact is that it is being violated on a daily basis through existing legislations where the courts are not striking them down. And that's my greatest worry. And the last point I want to make is that this is a tour de force. This book is a tour de force. I don't think anybody other than Rohinton Nariman could have written this book with this clarity, with this depth of knowledge, with his perspicacity, and his understanding of the essential principles of constitutional law. So hats off to you, Rohinton.
Thank you.
Thank you.
Just a couple of minutes. By the way, Keshavananda Bharati, a few years before his death, gave an interview where he complained that he had never visited Delhi during those 66 days and never seen or met Palkhiwala, his main lawyer. But 2 points. One is, conceptually and philosophically, what is basic structure? And it's important to repeat that to ourselves. It is a recognition, ultimately, of all these things we talk about every day. It's a recognition that power corrupts and absolute power corrupts absolutely. It's a recognition that many, if not all, dictatorships are constitutional dictatorships. We tend to forget that. It is a recognition that anti-majoritarianism is part of the bulwark of constitutional rights. If majorities could do everything, there'd be no need for constitutions. And the other thing which follows the basic structure is that, yes, in theory, the constitution is supreme, and within the constitution, the basic structure is supreme. But the gatekeepers and the interpreters of the constitution, and therefore of the basic structure, will remain judges. So now we know who is supreme. They are the gatekeepers, they are the interpreters. And I think that's something which we have to not cavil about, because that is an area where we put our trust in an institution, which will ultimately, by interpretation, make some mistakes sometimes, but will ultimately defend that bulwark of freedom.
The Constitution is supreme.
Constitution is supreme is the biggest, one of the fictions we're talking about.
That's the most dangerous thing to say, that the Constitution, because you interpret what
No, that's the point. I'm saying the gatekeepers,
But then
the
there has
gatekeepers and
to be some
interpreters.
institution which has to
That's
do
right.
that job.
That's exactly
And
the point
It
I'm
can't be other
making.
than the judiciary.
That's exactly the point.
I have been at pains to point out in this book more than once that the Constitution trusts only 5 learned judges of the Supreme Court to interpret it. And that is Article 145(3).
Yes.
Yes. And the second point was, apropos the practical aspect of which Kapil commented on, that this is an important legal issue which some constitution bench or 7-judge or 9-judge bench should decide. There appears to be a line of thinking, as Arvind and I discussed, that ordinary laws cannot be struck down on the ground of basic structure. Only constitutional amendments can be struck down. It is taken supposedly from some words of Justice Matthew in Indira Gandhi.
It's a one-off.
Those
And it's wrong.
Justice Matthew's words are probably seen out of context, been followed unfortunately in other judgments, including Kuldeep Nair and Anjum Qadri, etc. The result is that a very large mass of things which can actually destroy very many aspects of the basic structure are unchallengeable unless they are constitutional. This area must be legally revisited. And Justice Matthew's comments in Indira Gandhi Nehru don't really go all the way. They are being picked up by later judgments to suggest so.
Yes. Now, we just, the program says question and answers for 5 minutes. Anybody has any Q&A? Yes. I would request, because we're running out of time, just only the question, no comments, just the questions, please. Yes. Yeah, I can pass on the mic, yeah.
No, it was not working. No?
He was very generous with this mic because it doesn't work.
Congratulations, Justice Rohinton. In today's digital age, where India has already begun its journey towards becoming a cognitive colony, where Indians have begun to start vomiting data on a daily basis, where we are more relying upon chat GPTs and AI rather than our cognitive freedom, can we actually say that my right to digital sovereignty, my right to cyber autonomy, my right to digitally vomit data, my right against cognitive colonialism be read as an integral part of the basic structure of the Constitution, and would it really warrant any subsequent recognition by the courts or protection? Thanks.
I think this is the next PIL now. Yes. Anybody else? Any other question? No, it's an important point, but I don't know what ultimately freedom of speech and the yes. Yes, please. There. So you can. You want any particular panelist to answer? You can ask.
I will just concern rather. because independence of judiciary is an integral part of basic structure. But when Parliament negates the judgment of the Supreme Court, and we have recently Election Commission case, and we have the Delhi Civil Servant case, and that goes on, and recently we have the Governor's judgment, Supreme Court judgment. If that is negated by Parliament, by law, then there is a threat to the judicial, this doctrine of basic structure. That is my concern. Thank you.
Yeah. Yes, please. And that's the last.
Sir, I wanted to ask Justice Nariman, by not allowing ordinary legislation like a Representation of People's Act in Kuldeep Nair case to be tested on the grounds of basic structure, is that not a danger that federalism was affected by those amendments? Or, for example, under PMLA, you have those draconian provisions which are difficult to challenge. This judgment has said in that UP Madrasa case that if you allow ordinary laws to be challenged, then it is a great danger that you give the leeway to the high courts, and it may not lead to any coherent jurisprudence on that.
First and foremost, as I have pointed out in the book, basic structure is not an extraterrestrial concept. It lies in the actual wording of the articles of the Constitution. So, if you wish to challenge an ordinary legislation, look at the ordinary wordings of any article. Don't call it basic structure, but if it offends any article, that is itself a superior law, get it struck down on that front. So my answer, therefore, would be that there are many articles which may pertain to basic structure, may not pertain to basic structure. But every single article of the Constitution is above ordinary law. And if you test it, therefore, against any article of the Constitution, whether it pertains to basic structure or not, and if it falls foul of that article, it will fall foul.
May I just respond? Yeah. See, the problem lies here. If it's not exercise of constituent power, it's exercise of ordinary law, then under Article 13, if it violates Part 3, it can be struck down. But you have a Supreme Court that doesn't strike it down. If you had the same law passed through a constitutional amendment, it would be struck down, as it would be violative of basic structure. But the ordinary legislation, which is contrary to basic structure, is upheld by court. Supposing we were to pass a law saying that no particular monument will be demolished, let's assume, right, of a particular community, it would be struck down. But if the ordinary law says that you can do it, that's not violative of basic structure. So there's a real problem that I think our country is going to face.
But then the question would be, as rightly mentioned by Justice Rohinton Nariman, we'll have to look into the text of the Constitution, that whether it violates any other provisions of the Constitution.
But it is upheld, supposing it is upheld.
Here minority rights are there. I mean, it's the Constitution.
The way out is to change your judges.
No, but this is a conundrum that comes up and will come up in times to come.
Yeah, I'll just make my short comment on this basic structure and ordinary laws. I've always, as a student, I've always thought it paradoxical that you can strike a constitutional amendment as violative of basic structure but not an ordinary law.
Correct.
If basic structure means the essential features, in African countries and in Pakistan they call it structural pillars. If these are the essential features, like say for example separation of powers, where is it mentioned anywhere in the Constitution? But if you got a matter where suppose tomorrow, we gave the example in the Madras Bar case, suppose it say because there's too many check bouncing cases, we put it to a banking tribunal consisting of some 2 retired general managers, and they can sentence a man to jail also. That's a banking law, but I dare say it will be struck down because if separation of powers has been held to be violation of basic structure, an ordinary law can be struck down is my humble view.
That's a debate that we want.
And ironically, Chief Justice Beg in state of Karnataka was Union of India. I was reading the law.
Correct, one off.
Yes, there are comments which say cannot be. Justice Keher in the National Tax Tribunal, Justice Beg in this particular thing, has said that you can, ironically, that you can strike down an ordinary law also on ground of the basic structure. In fact, Justice Matthew's observation is more like an obiter. There is no plus and minus. He simply says it can't be. Why not?
No,
nobody
he doesn't
says.
explain
So
that.
my humble view is that tomorrow, if a matter comes before the High Court or the Supreme Court and if it's violating basic structure as enumerated by the Supreme Court, even an ordinary law can't pass muster. Okay.
Much less an ordinary law passing.
Yes, you're right.
Thanks. Now my pleasant duty to make the closing remarks. Thank you all for coming, and I must tell all of you that this is an absolutely fabulous book. What I liked about the book was that Justice Nariman has taken the trouble of taking the minority judgment. You see, we keep on saying Keshan Bharati, Justice Khanna and basic structures, but nobody bothers to see what are the minority views. If it was 7:6, there must be a very strong ground. And as Justice Viswanathan said, the judgments of Justice Palekar, Justice Matthew, Justice Chandrachud, extremely closely reasoned and very, very compelling reasons not to accept basic structure. And one must put ourselves in a time machine and see those times when they thought. And it is ironical that all of them said that we can't imagine any parliament doing something outlandish, as Justice Nariman said. And it's a strange irony that within a few years after basic structure, you had the 39th Amendment, which exactly did what people said could never have been done. The beauty of this book is that he has taken the minority views and then given his comments as to why it is not correct. The other important thing I say, those of you who buy this book, please make a note, please go to page 302 of this book. And it is an irony that Justice Saqib Nisar of the Pakistan Supreme Court has made a table, it's amazing, where he has made like an Excel sheet all the cases from Keshan Bharati, Indira Gandhi, Minerva Mills, Vaman Rao, Sampath Kumar, Samba Murthy, and he has highlighted which are the points of basic structure and which judge said what. So this is really a remarkable thing which Justice Nariman has taken the trouble of finding out. And he has also mentioned how the law has developed in various countries. Those of you interested, perhaps the best book on this is Yaniv Roznai's book, Unconstitutional Constitutional Amendments, where he has studied 700 constitutions from past thing, and then he goes into various cases where the basic structure has been adopted.
He also commends Keshwan and the Bharati.
Yes. And he says India is the forerunner. Singapore and Pakistan, Singapore and Sri Lanka have not accepted it because their constitution permits complete abrogation of the constitution itself. And I just mentioned one thing because I was involved in writing this Courtroom Genius with Mr. Sorabji. And I had the benefit of doing large number of interviews, including late Justice Y.V. Chandrachud. And I'll just mention a story that Keshan Bharati may not have been necessary if Palkhiwala, that's what, there's a very famous solicitor from Bombay called D.M. Popat. Yes, of Mullah and Mullah. Sajjan Singh was being taken up. And mind you, in Keshan Bharati, like in Sajjan Singh, it is just not His Holiness Keshan Bharati. The second petitioner is Raghunath Rao Ganpat Singh and a Nawab, and there are other petitioners who are sugar mills and mining mills and so on. So they also were actually in the litigation. Similarly, in Sajjan Singh, there were a large number of industrial companies which were involved. Sajjan Singh had challenged the 17th Amendment, where at one stroke, 44 laws were put into the basic, into 9th schedule, and it was completely held unchallengeable. Just for a passing moment, Nariman makes a very compelling reason that if 31B itself is violative of basic structure, because you can't have such a situation. Anyway, so coming back to Sajjan Singh, Palkhiwala was briefed for 3 sugar companies to appear, and he hated to wait. So he told Popat that when the matter is coming up, I'll come and argue the point. And in the discussion, he mentions it in Gujarati. And what they were discussing, Popat and Palkhiwala and others, were that, look, if you say amend, can they take away freedom of speech? Can they take away 21? These were the actual questions. So he says that, is there some line beyond which the parliament cannot cross? So he said, well, let's put this point to the Supreme Court. He was going to argue the next day, but Justice Gajendra Gadkar said, arguments are over, we are not going to wait for anybody, and the arguments closed. So one of the ifs of history was, if he had been there, because it was 3:2, Sajjan Singh. So one argument, if Palkhiwala was there, maybe it would have been 2:3, and Keshan Bharati may not have been necessary. But that's just one of the histories of this thing. Other thing I'll mention is Dieter Conrad's article. I managed to get a copy of the original article, which is underlined by Palkhiwala. And if anybody is interested, please tell me, I'll mail it to you. And in this article, which is underlined by Palkhiwala himself, as Justice Nariman mentioned, it's an article written in 1966, delivered, I think it was Banaras Hindu University, he lecture in Banaras University. And he makes a very important point. He has seen the 1965, just after the Sajjan's 17th Amendment. He makes a very interesting observation. He says out of 17 amendments, 5 are for political reasons, state reorganization and so on and so forth. But he said the very surprising thing of the Indian system is that almost every amendment is to overturn a Supreme Court judgment. And he says that destroys the trust in your system. So he makes a very strong observation that if every judgment is going to be overruled by an amendment, then it's not healthy for the rule of law. And of course, the other point meant. But it's a very, very compelling article, which is worth reading. And it's almost deja vu, like what he expects what to happen. And he concludes by saying, I hope that India will have a brighter future and so on and so forth. So this is as far as Konrad is concerned. Friends, we've had a wonderful evening. And I would definitely say that this has added a great deal to the scholarship of basic structure doctrine, is something which we should not forget. And I'll conclude by saying that the main criticism of basic structure is that it is anti-democratic and counter-majoritarian. I'll only submit in my own view is that the purpose of basic structure is not anti-democratic and counter-majoritarian. It's actually to protect democracy from a majority. Thank you.